This is Chella Law's weekly webinar, and we're going to talk about the latest immigration topics that impact your filings. Today, there won't be any Q&A because right now, as you can see, I'm at my parents' house, getting their blessings for, my 30th birthday? No, I won't tell you. 56 today. There's no shame in my game. So let's go ahead and get started with the latest topics. We'll give people a few minutes to log in, and then we can get going with the latest. So today, we're going to start talking about the USCIS extends flexibility for responding to requests for evidence. What happens if the government shuts down? Remember, Congress is now trying to make sure that the funding bill is continues. So if the government shuts down, what about preservation of priority dates and interfilings? So first, let's talk about processing times. I'm sorry, there's a plane going overboard, but I hope you can hear me. So why is my case taking so long? Processing times have jumped anywhere between 50 to 250%, depending on the type of filing. Inefficient processing, understaffing, changes in the policy due to the pandemic have all contributed to these delays. If you remember, the third quarter of last year, and you were on the webinar where we talked about this data, it was unprecedented how many cases they approved. But then what happened? The temporary workers or the 1099 workers that they were using, they had fired because they didn't have enough funding. Even though there's some funding that is given by Congress, the USCIS is a self-funded organization. And during President Trump's era, because the number of filings decreased because of the pandemic and other immigration restrictions, they had to cut their budget. And so how they did that, they fired all their, not direct staff, but their indirect staff. So the last administration implemented policies to, the last administration implemented policies to restrict immigration and delay processing. Remember, they removed the deference policy, and where they said that if you're filing an extension for the same company, same position, you're no longer going to get deference that it was approved before, that they were going to look at it anew. And that allowed them in the H-1B realm that allowed them in the H-1B realm to be able to deny for specialty occupation when they had been approving that petition at least 4 different times. Now, this policy has now been removed, but the backlogs were increased due to this. And like I said, the removal of the contract workers. So what can you do? Make sure USCIS and your attorney have your updated contact information. File extensions and applications as early as possible. Discuss outcomes required or actions if USCIS processing is delayed. Submit the documentation. Try to make sure your application is as complete as possible, so you could deflect getting an RFE, which would cause additional delays. Try to submit your medicals with your I-485 filing, because that way you don't have to worry about doing that at 2022. USCIS will consider responses received within 60 calendar days after the response due date. It also applies to decisions eligible for notice of appeal or a motion up to January 15th, 2022. This is the 8th time the flexibilities have been extended since March 2020. What happens if the government shuts down on Thursday midnight? So the AILA practice alert says if Congress fails to pass the budgetary measures ahead of the September 30th deadline, and government personnel are furloughed and cannot work except for essential workers. As I said, USCIS is fee funded, so typically most workforce will remain. Exception is programs that receive appropriated funds like E-Verify, EB5 regional centers, Conrad 30 J1 programs, and non-minister religious workers. DOS and visa passport operations are fee funded and normally impacted and normally not impacted. So consular operations could be impacted only if there is insufficient fees. The CBP and law enforcement personnel are essential, but processing applications at the border could be delayed. ICE enforcement and removal operations, of course, will continue. SVP is unaffected because it's a fee-funded operation. That's for F1s and so forth. DOL case processing applications, they'd not be able to respond to email or other inquiries. Flag or perm systems would be inaccessible, and all the bulk dockets would be on hold. So let's talk about interfiling. Leveraging your petition from your previous employer. As we talked about last week, as I have been saying, it is best to make sure that you have both an EB2 and an EB3 if you can. The reason is you can do interfilings. And so maintaining your priority date. What is a priority date? The filing, it's specific to the individual. So a lot of times people will say, my spouse has got an I-140 approved. Can I use that spouse's priority date? No. You can do things like if your spouse is born in a different country and that country has no backlog, you can try to leverage through their priority date on your petition. That is allowed, but you can't leverage their priority date based on their filing. So once you're assigned a priority date by approved employment-based petition, that attaches to you, but the petition has to be approved. So it's not the perm. The perm, when filing the perm, if you're doing it in an employment-based process, is the priority date that you're issued, but it doesn't attach to you until it doesn't vest with you until the I-140 is approved. And once it's approved and it's not invalidated because of fraud or misrepresentation, you can use that priority date for any other subsequent filings, which is always good. You can leverage a petition from a previous employer as long as there is, so especially with these dates coming up, some people say, can I go back to my previous employer? Well, you can if there's a bona fide job offer, no fraud. So what do you need to do? You need to demonstrate your present intent to the worker once the green card is approved. You should make sure that there's written communication, confirming your present intent to work for the employer, either emails or maybe a contract or, a memorandum of understanding between yourselves. And you don't have to work for them until the green card is approved, but you need to demonstrate that you will work for them once the green card is approved. And if you subsequently change your mind, that's okay. But at the time of filing the I-485, you have to have that present intent. And like I said, you can leverage your AC-21 for same and similar employment. As long as the I-140 is approved, the I-485 has been pending for 180 days or longer. So how do you take advantage of the shifting visa bulletin and interfiling basics? If you have multiple I-140s approved for the same employer, you can interfile your I-140 based on what is advantageous with the visa bulletin. USCIS doesn't use the word interfiling, but they use it, they call it transfer on a basis of a previously approved petition. So there is no form for interfiling. You would just take a copy of your I-140 and you would reference your 485 with the current pending I-140, and you would just request the USCIS to utilize the I-140 that was not the basis for your I-45. So if you have an EB2 and an EB3, depending on how the movement is going, the USCIS does say that that you are permitted to leverage the priority date for the petition for either petition. So you will be able to do that. But in order to interfile, number one, the current I-140 that's with your 45 has to be approved. So you would need to make sure that the I-140 is approved, the current I-140, before you interfile. And if you file a new I-140 to be interfiled before the approval, but then it's denied, both the I-140 and the adjustment of status would be denied. So as I mentioned earlier, we're not going to really do Q&A today, so I can have lunch with my parents, but we will probably be doing a Telegram live. So you can submit your questions to the Telegram community. And it's a great community where people who are going through the immigration process, will give you their experience, their information. And we also chime in once in a while to provide our insight as well. So, Shaker.
Yeah, I'm here wishing you a happy birthday. Lakshmi.
Thank you.
Looking very good and bright and shining on the back. Good background.
Yes. Yeah, my mom's porch is always very nice.
Yeah, say hello to your parents. And so I guess you announced there won't be any Q&A because you can.
No, but we may do, if you all signed up for our Telegram group, we may do a live Q&A tomorrow on Telegram where I'm just going to be answering questions. So I'm going to ask Kara to put a poll up to, she's attached the Telegram group link and put a poll up in Telegram asking them what time would be best for us to have just a conversation where we can answer questions. We are one of the few forums that will do that for free. In other forums, they'll have attorneys come in, but if you ask them a question and they would expect that you pay a consultation fee. Here in Telegram group, we're not doing that. We are trying to be a resource for the community. So I thank you all for chiming in. Those who joined today for the first time, welcome. Those on YouTube Live, hello. And those people who have been joining us every week, I thank you for your commitment and dedication. And got a shout out to my team who's done a great job in organizing this. And of course, our very nice moderator.
Thank you. Have a good birthday and good lunch, and I'll see you soon.
Thank you. Bye-bye.
Bye, everybody. See you next week. Looking good.